kill to deal with people who take cases to court. I'm just giving you examples. The second example is where a president continues to abuse power, goes to America, enters into secretive treaties, binds Kenya to become a non-NATO member. That's a matter under Article 2, which requires not just parliamentary approval, but approval by the citizens to enter into deals like this through a referendum. It is a significant enough matter. And the president goes on to, number 3, for example, enter into a situation where he's given a gift nearly 200 million worth of in an aeroplane to fly and fuel to fly to America. Yet he knows that under Chapter 6 of the Constitution, he needs to actually declare anything that is above 20,000 according to the law and the Constitution. So the list of examples, the president establishes a parliament which does not meet the not more than 2/3 gender rule. He not only violated that the Constitution in the first round, he has done it again just now, this exercise that is going on. And the parliament will never raise a finger to say that you've actually violated the Constitution and you need to go back and constitute a cabinet that is constitutionally compliant. We have 31 instances where the Constitution has been violated. So those cases are in the application, which is now available, I think, globally. And so we said that as Kenyans who were involved in the birthing of the Constitution of Kenya 2010, a lot of the petitioners are people who have gone to committee, have gone to many, many police cells. We've buried many colleagues who have died in the struggle for a new constitution. And we said that we cannot stand and watch as a tyrant takes power, abuses it, dissolves our constitution, almost suspends it, which is currently the situation that the police, we have become a police state where the president has basically suspended the constitution, and he can defy it with impunity because he knows that impeachment proceedings will never be brought against him in parliament. So I want to pause there for now and say that in the face of the Gen Z and the millennials revolution, you've seen that Article 10 has been violated in the open. 93% of Kenyans say no to the finance bill. Then Parliament goes on and passes it anyway, in flagrant violation of the Constitution about public participation. So that the crisis now is that the president and Parliament do not have the legitimacy to govern. What is left to us then is to look for a constitutional route of removing the president and his deputy from office so that Kenyans can be able to elect the head of the executive who actually has the legitimacy and who abides by the Constitution and the oaths of office that they swore to uphold at Kasarani. Thank you so much, Eric, for that.
Thank you, Cyprian. Naomi Barasa is one of the 14 petitioners. Naomi, you have the mic now. Let's hear from you. Yes, go ahead, Naomi. Unmute your mic.
Thank you so much, Eric Latif, and thank you to all the speakers that have spoken before me. And thank you so much, Cyprian, for just laying that background. And I would just want to focus so much on our role as Wanjikos of these countries and the reason why we have gone to court to seek the direction of the court in terms of exercising our mandate as Wanjikos, because besides enjoying the rights as guaranteed in the Constitution, we also have the obligation to protect the Constitution. So to begin with, I just want to state that what we are doing is clearly protection of the Constitution, defense of the Constitution, which is very critical for every Wanjiko of this country, because this is a document that was established with our sweat, blood, and lives. So we cannot even dare play with it. We cannot watch people mutilate it. Otherwise, it will be too much sacrifice in vain. I want to begin with me as a mother. I am a mother of Gen Zs. And when it gets to a point, our children can no longer continue living the way they are living, because, as it were, they cannot breathe. So the young adults, young Kenyans, who are by all means constitutionally have the right to demand for constitutional rights in this Kenya, go to the streets. And just using Nairobi, for example, at one point there were around 2 million people, and they speak, and their president cannot listen. For me, I think keeping quiet will be contributing to the same mutilation of the Constitution. So for me, a president who ignores the voice of Wanjikos, for me, I think then ceases to be legitimate in terms of protection of this constitution. And I just want to add on to the few things that to add on the few cases that Comrade Cyprian has cited to, in terms of ignoring the voices of Wanjiko. Let's begin with the housing levy. Look at how many people spoke against the housing levy, and this very president looked for all manner of ways of circumventing his way, and he did everything he did. Even when the court said this is unconstitutional, he still went ahead. He had his way. Look at the finance bill. Comrade has elaborated on that. Look at the Haiti case, and where we sent 1,000 police officers to Haiti. We were opposed to this as Wanjikos of this country, and even we got the reinforcement of the court. But what happened? We still had our police officers going to Haiti, even when the court categorically pronounced that this was unconstitutional. And if it was anything we wanted to participate on in terms of offering support or mission for peacekeeping, it wouldn't be the police. It would basically be the military. And the case for Haiti did not qualify for that. It was ignored. We have also seen lots of Kenyans who have not supported Israel in the attack for Gaza. But what has William Ruto done? He's gone public and even pledged support, the Kenyan people's support for Israel on our behalf against our wishes. That's number one, ignoring the Wanjikos, the voice of Wanjikos of this country. And that, for me, pokes a lot of holes on the sovereignty of these Wanjikos. And I don't know if one William Ruto understands that. The second thing is just how he has managed to trump on the constitutional rights of the Wanjikos. Extrajudicial killings, children cannot go to school, sick people cannot access education, we cannot access information where need be. I mean, a lot of this. We've also seen a lot of, we've witnessed a lot of abduction. We've seen people, police arresting arbitrary. All this is violation of rights. And then we've also seen a lot of corruption and the opulence that comrades have talked about. And instead of the president overseeing accountability, what he has done, he's blessed case by case to be dropped for people who we clearly see that have cases of corruption and demand that require accountability. And what has he done after their cases have been dropped? Appoint them in public office. So we think that with all this, he has no capacity to protect the very constitution he vowed to defend. And so
Okay.
for that, as a Wanjiko, I feel like he's lost my mandate.
Thank you. Thank you, Naomi.
Eric,
Yes.
I would wish to inform you that we have Kibe. He's standing by.
Great.
So Kibe,
Kibe will speak shortly.
this is your cue.
Let's hear first from Janet. Janet Ouko, also one of the petitioners. Let's hear your voice on this.
Thank you very much, Eric, and my fellow countrymen for this opportunity to just get to share one of the very exciting opportunities that I get to contribute, to my country. I really feel very excited about the idea that we can have another alternative, that we can be able to help ourselves as Kenyans, and that we do not have to succumb to the fact that even if our president is offending the constitution, then we are doomed for 5 years. I think for me, this is going to be very good news for the very many people who are feeling tonight that really is like the political elite of this country are coming together to perpetuate or to try and really suffocate the voices, even of children. You know, we've been in this country and we've said a lot, but seeing children really even calling us out and calling things out and still finding a political class that cannot listen and cannot do the will of people just because they know they have secured themselves. I really want to associate myself with the comments of my colleagues, Cyprian, and of course, Naomi, that have spoken before me, because we feel that we have got a lot of evidence, and these issues are out there. Kenyans have been speaking about them, that we have a president and a deputy president that do not spare any opportunity for them to offend the constitution. And my question is, what happens to that? Because you cannot govern this country using any other thing apart from the constitution. We do not want anybody that will govern us from their head or from some motivational notes or some verses of the Bible. We actually must entrench constitutionalism, and we make sure that the president rules us as per the constitution. Now, in the event that he does not do that, what recourse do Kenyans have? And I'm really thanking God, because we've spoken with our lawyers and they have explained to us that actually we have an opportunity as citizens of this country, because as our lawyers have explained, that there are two ways that we can do this: directly or indirectly. Indirectly has failed, because indirectly means through our elected representatives. They are not likely to do that anytime soon. As speakers have said before that, we have tried to raise our voices. We've been hoarse, telling Parliament, no, do not pass that bill because it is killing Kenyans. They go ahead and do it. Do not pass the housing levy. It is offensive to so many Kenyans. They still go ahead and do it. Seeing tonight that we as the people, that Kenyans can have hope, that they have another alternative route, I really want to rally Kenyans around it and appreciate the immense role that we have of educating Kenyans and letting them know that they have another opportunity. It's really sad, even like what is happening tonight, you know, seeing political elites coming together because they have known that maybe we do not know this other particular route. I have seen comments, even associated with the Speaker of the National Assembly, saying that the Gen Z should be told that the president has got a 5-year mandate. And I ask, even when he kills us, he must stay on for 5 years? Really, are Kenyans that helpless? Is our constitution that helpless that he must stay on for 5 years, even when he kills us, even when he offends the very basis of framework, which is the constitution that he's supposed to rule by? Because I think for me, yes, he was voted in, but it was on the basis that he would rule us according to the constitution. In the event that he does not do that, as we have demonstrated, I come from an education background, and I really feel sad because some of these issues don't get to be mentioned. We have not had another situation in this country for the last 15 years that so many children are home. We have got capitation grants that have not been sent to schools for quite a long time ago. We have a president who found a capitation of 22,000 per child per year. He has reduced it to 16,000, and he's not even sending it with fidelity without Parliament questioning him. Article 53 of the Constitution of this country grants the children of this country free and compulsory basic education. Who is this that comes and strips that off them with no question from anybody, sort of running it? If today he feels like reducing 10,000, reducing two, and even reducing it to zero, he has got no question. So I think really this is an opportunity that we really pray to God that we seize it, and we show the political class of this country that yes, it is a 5-year contract, but with conditions. Thank you so much.
Thank you, Janet. Everybody who's joined us as we in the middle of the conversation, thank you for joining. This conversation is based on a petition that's been taken to court by 14 Kenyans who have come together under the umbrella of the Kenya Bora Tuitakayo, and they are seeking to exercise and to test the powers of this constitution. I am not part of the petitioners, and I am not part of the movement, but I'm hosting this conversation because it's one of those interesting times that we are in. We have seen in terms of agitation for the recomposition of the IEBC, because there are people who have said we'd like to see how we can recall a member of parliament. We have hosted on our show on Spice FM the people of Kabete who have started a signature collection exercise. Now, this one is another one which is more direct on removal of a president. So, what we know is that removal of a president that has been written in clear ink in the Constitution is found in Article 145, where a president is removed by impeachment, and this will require a member of the National Assembly, supported by at least a third of the members of the National Assembly, moving a motion for impeachment. And there are 3 grounds: gross violation of the Constitution. There are serious reasons for believing that the president has committed a crime under national or international law for gross misconduct. And if that is supported by at least 2/3 of the members of the National Assembly, then the Speaker of the National Assembly informs the Speaker of the Senate, and then it moves to the Senate, where the Senate conducts a hearing, and the president is given an opportunity to be heard by the Senate, and then the Senate again by 2/3. If they vote yes to impeach, then the president will then stand impeached. Or if they don't get 2/3 of members of the Senate, the president stays in office. Or if the committee investigating this finds that the issues that have been raised are not substantiated, then the president also stays in office. But these 14 Kenyans are going to court and they're saying, we are the sovereign of the republic. We, under Article 1 of the Constitution, hold sovereign power, and we may exercise it directly, or we may exercise it through our democratically elected leaders. And we've heard from the lawyers here, and what they're saying is we want to exercise that and other articles of this constitution, and moving to court to ask the court, can we hold a referendum to recall a president, to remove a president from office? That's why we're here. One of the other petitioners that is also on this call is Professor Fred Ogola. Let's hear from you. Prof, go ahead.
Yeah, thank you very much, Eric. Thank you very much, all our listeners. I think this is an earth-shaking and groundbreaking petition, and that's why there are so many questions. I'll just make the following submissions. We are being told that the constitution is being violated. That is true. And the state want us to believe, especially politicians, that there is nothing we can do. And that's why they are trying to tell you, you can only act according to this way because that's what works for them. But Gen Zs have demonstrated to us that we can use we can't you cannot be able to use the table manners that they are giving us. That's why you saw they are completely mold breakers. Just they don't want to be confined by any other things. That's why they just went to the city and said, "What's happening? We are entering parliament. We are invading and occupying this place." Have you seen them giving police permits and the rest? So politicians always want to confine us and want to make us believe there's nothing we can do beyond what is there. So what I'm trying to say is that there's a constitution we have, but there is no constitutionalism. These are not my words. These are words of the likes of Yash Palgai, among other professors of law. So this, what's happening? That let this petition that we are putting across be that petition that will advance the so-called constitutionalism. And just because we don't want to have legal jargon here, the constitutionalism means that the constitution alone does not secure or bring about constitutionalism. So the constitution we have might not. And we need to be courageous to bring that so-called constitutionalism. So let KBT, through the petitioners, create these precedents, because I'm sure why we are thinking it might not happen either that no one has done it. And maybe let's be inspired by some of the guys, Eliud Kipchoge, who says that human is not limited. I'm sure we are not limited by here. And these people are trying to tell us that our rights are limited. We are not, our rights are not limited because of the fact that we are the one who caused these institutions even to exist. So we should not actually be really worried. So the main question this petition is going to answer, and I'm sure Cyprian has put it even clearer in other forums, that what do we do to a president or the presidency, because Gachagua is also there, that breaks the law but cannot be impeached by parliament? And even if he's told, he cannot listen. He thinks he's untouchable. Power has entered his head. He does not even understand where Kenyans are vis-a-vis where he is. Like a president whom people are crying about economic issues, for him he has come up with the political prescription of putting opposition inside government. And I'm sure, Cyprian, there should be a violation there. I'm even finding ODM violating. So if in fact, if you can impeach opposition, I'm sure they should be impeached as well. So that question can only be addressed by the fact that the constitution is not impotent. The constitution is not helpless. The constitution is not hopeless before the leaders because of the fact that who creates them? First of all, God creates us. God creates us. God is the cause of causes, the first cause. Then, after causing, God causing us, we become Kenyans. With the Kenyan people, we give birth to our sovereignty. Our sovereignty gives birth to the constitution. The constitution gives birth to institutions, which is now state house, presidency, parliament, and the rest. So, how can your cause be helpless before you? It's impossible. So we believe that there's a mechanism, there's a legal infrastructure to do this. When you cannot keep the constitution that elevated you and put you in the office, then the very constitution should lower you. Because remember, when Gachagua and Ruto were even crying, "Don't kill my children," they were below, they were very below, and immediately they were declared president and deputy president elect. The constitution elevated them to that level. And by being sworn in, now they were at that level. So it is the very constitution that elevated them to that level, the instrument of the constitution. And the same instrument of the constitution should be able to lower them if they do not keep the constitution. And they saw that in the allegiance they took, in the execution of their office. So for that matter, you should everybody should know, and we should send this message, this petition, that you keep the constitution keeps you. You throw it away, it throws away. So the supremacy and the sovereignty must prevail now, and it should actually prevail forever, because this petition will be asking the questions that, can High Court, using the 5-judge bench that has been requested, set up by the Chief Justice, determine that these violations are okay? And because evidence is there, if they say yes, even if they are 10 or 15, that's enough. The second question is, I think between the Constitution and the president and deputy president, who is above the other? This is so obvious that even if you are a lawyer who hates KBT, you'll simply say that if you are a judge who hates KBT or hates Kenya, you'll just say the constitution is above. So if we violate your boss, which is the constitution, are you fit to be in office? Then you declare that you are not fit to be in office. But then the question comes, if you are fit, you are not fit to be in office, and in your office, is the constitution helpless just because there's no procedure like has been explained by Lampa? No, there should be a procedure which can be created, and even if it does not exist, this will create necessity. In fact, there's what you call the doctrine of necessity. If there's a necessity to do something, you do it. I'm a Catholic. Cyprian Nyamongo here is a Catholic. The person who should do baptism is a priest. But if someone is dying next to me, I'm allowed to baptize them. If they happen not to die, then the priest will baptize them later. But if they die, they're considered to be in the kingdom of God. We must be in the kingdom of God as soon as possible. Unfortunately, the judge has said we are giving more time. We thought it was going to be soon, but nevertheless, we will be in Canaan. Thank you.
Thank you very much. Thank you very much, Professor Gola. And just like Professor Migaya Kech had explained earlier, I mean, this is doable. It's a substantive versus procedural issues. Professor Kibuda Kibwana is on this X Space tonight, and there's a request that, I mean, you have been requested to join in as a speaker, Prof. Join in at some point. Let's bring in Advocate Kibe Mungai, who's one of the advocates handling this matter. Advocate Kibe, are you here?
I'm here, Eric, and good evening, everyone, for the delay in joining in.
Karibu sana. I want to ask you now the procedure that you're seeking and what you're asking of the court. Okay. So number one, we've been told by Wakili Lempai there are several requests and pleas that you've taken to court. You want the constitution of a bench and several matters. We have seen from the Constitution, Article 145, that if you were to impeach through Parliament, there would be certain thresholds that have to be met, so that you're not just removing a president whimsically, so to speak. In the way that you are approaching court, what safeguards are you seeking to use to remove a president? And what does the president get in terms of fair administrative justice? Does the president get to, and the deputy president, do they get to also come to court and be heard?
Thank you for that question. The starting point is that the first and second respondents in this case is actually the President Ruto himself and the Deputy President Rigathi Gachagua. And the approach that we have taken, and I've had some explanation of how it's supposed to go, is that when, for example, Parliament is the one that is conducting impeachment proceedings, what usually happens is there is an indictment by the National Assembly. If this indictment is successful, the Senate constitutes itself to try the president. And the president would have an opportunity, like in a normal court, to defend himself against accusation of either gross violations of the Constitution, abuse of power, incapacity, and such other reasons. Now, when therefore he is found guilty, the Senate in effect would be acting like a court. Now, for purposes of the direct procedure, the reason for using it is that the Constitution declares that the supreme authority, by saying that the sovereign power lies in the people, is another way of saying that the people are the supreme authority in the Republic of Kenya. And it is because of that, people being the supreme authority in the Republic of Kenya, that we elect the Parliament, members of Parliament, and we also elect the president and the deputy. So the normal law of agency, we are aware that the people, and President Ruto said that in his last speech before the last general elections, that the people have the right to hire and fire. So that the right to hire necessarily presupposes that you can fire. Since the President Ruto and his deputy were hired through the direct vote of the Kenyan people, it would follow that impeachment proceedings, they can be removed by the representatives of the people, and the Article 1 is clear that the people themselves can exercise sovereign power directly. The exercise of sovereign power directly in this regard would require them, like in this instance, to convince the High Court that indeed the president is either incompetent has grossly violated the constitution and engaged in abuse of power. In the petition, and Cyprian has explained it, there are at least 36 instances in which the president has seriously violated the constitution, including deployment of the army, including leasing to the Americans airfields in Lamu without following the due procedure, including engaging in the capture of parliament, which has made it practically impossible for it to hold the government responsible, unlawful procurement of loans, and the general abuse of servant leadership to the extent that the people of Kenya have been taxed unfairly and oppressively, and this money has been misused. And this is what led recently to the people of Kenya, through the Gen Z, whom I commend, to demand that the Finance Bill 2024 could not be passed. Therefore, I wish to confirm that indeed the president will have an opportunity to come and defend himself. If he is found that there is even a single violation or abuse of power, then the IEBC would be required and would be entitled to hold a referendum so that the people of Kenya, as the ultimate judge in this process, can be able to determine, based on that finding of the High Court, whether his term in office should be terminated and therefore he is removed from office. But if the majority are in favor of him remaining in office, then he will remain in office. This, in my view, would be an important way and the first time in the world where this direct exercise of power is manifested this way. But let us also remember that Kenya was also the first one, because in the year 2004, and Cyprian was one of the petitioners, we went to court and convinced the High Court that you could not get a new constitution without a referendum. And the constitutions of Kenya, therefore, unlike any other constitution in this world, was adopted on the final vote that was taken. I think this was 4th or something of August, the year 2010, then promulgated on the 27th of August. And therefore, the sovereign power of the people, we want to lead the world, because already the concept is accepted under our constitution, in which all elected officers that do not have to be in office for 5 years. In the event that they violate the constitution or abuse power, they can be removed from office. And therefore, the notion that when I hear people say that you got a 5-year mandate, that is an ignorant and arrogant, because even parliament itself can impeach them. And if my agent or my servant, which parliament is, can be able to remove Ruto and Gachagua from office, then the masters of the ultimate authority, which is the people, can do the same thing. And it is important also to appreciate, I have heard today a lot of commentary in the advocates forum, people saying there is no express provision about how you can use the people for purposes of removal. But the simple question that you would answer that is this: in Britain, where they do not even have a constitution, when they wanted to leave the EU, the leaders of the EU say, since the political class cannot be able to agree themselves on the issue of removal, let us refer this issue to the supreme authority, which is the people. And the people of Britain voted for Britain to leave office. So in any democracy, the people of necessity are the supreme authority and can make any decision, including like in this case, where for some time it has been obvious that despite the fact that Kenya Kwanza government is incompetent, there is also the serious loss of legitimacy on the part of both the president and his deputy on their right to govern and capacity to govern in accordance with the Constitution of Kenya. Therefore, I am proud of the petitioner for this effort that they have taken. And I believe that we have an extremely strong case if I can compare that to the year 2004.
Wakili, let me ask you then, Does this go through the normal court process where if you start at the High Court, then it can move to the Court of Appeal and then go to the Supreme Court? Does that mean that we have to exhaust all avenues of appeal?
The way it goes is this way, that, and remember, there is a right of somebody who is dissatisfied, whether the petitioners or the respondents, to go to the Court of Appeal. And the final appeal in this instance would be to the Supreme Court. It is my belief that, except at the High Court level, where you may be able to take a little bit of more time, because that is where you are filing the bulk of the papers and defenses, any appeal arising from that does not have to take long. But in all this happening, the most important issue that would have to be considered is that now that the legitimacy of the president and his deputy to be in office has been questioned, it is in the interest of everyone, starting from the Chief Justice, the President himself, and the National Assembly, that this question is settled as quickly as possible. I am happy the High Court today gave directions on the filing of proceedings, of responses, which should end on the 16th of August. But because the High Court is on vacation, we were given a date, something like 24th of September, which is a little bit far. But there is a procedure in law where we can move the High Court after 16th of August to beseech the High Court to ensure that this court is heard during the vacation. The vacation ordinarily would end on 15th of September, but because of the nature of this case and the need to settle the issue of legitimacy of the current government, this is a case that should be fast-tracked. Therefore, it is possible to have this matter settled with or without appeals before October this year, and we go to the vote. I believe in the end, the people of Kenya should be invited to have the referendum and let the people decide, as Kenneth Matiba used to say.
All right. So thank you very much. So there are several people on the chats who are asking the questions, and maybe I just want to start with this one. Mugambi is asking, from a strategy perspective, would it have been better to file the petition in the Supreme Court if this could then go through all these other avenues? Is it possible or is it not possible? Wakili.
It is not possible. The direct answer is that the Constitution provides that the Supreme Court has a limited mandate. The only original jurisdiction the Supreme Court has is over the issue of either advisory opinions, number one, or number two, the presidential elections petitions. But in all the other matters to do with interpretation and the enforcement of the Constitution, the court of first instance is the High Court. And therefore, there was no other strategy that could have been used. The only strategy that is important here, and I believe we have, the petitioners have already asked that question and we agreed, is that a number of things can be done simultaneously. Even as we argue this matter in court, I told the petitioners that they can move ahead and to start preparing the people of Kenya for this petition, create referendum committees to coordinate this vote.
The more solid route is to go and ask the court for a procedural mechanism. As I said earlier, the people really do not need a reason to recall their executive if they so wish. As long as we're able to say that, look, give us some procedural thresholds. What is the threshold? Do we need 60%? What is the standard practice, for example? And this has been done before. The recall of a president is a very, very popular mechanism for exercising power directly in Latin America. So I just want to get a sense from the petitioners, what is it that you're asking the court to do?
Very good
Because
question.
I think my sense is that I think asking the court for a procedure is the way to go. Thank
Very
you.
good question, Professor Migai.
Let me answer that question. Eric, that's hi, Professor Migai. Thank you for that question. Now, the direct answer And thank you for recognizing that Article 1 establishes the substantive right of people to exercise their sovereign power directly. Now, on the procedure, I do not think that you need any procedure beyond what is already provided. Why do I say so? Article 3 of the Constitution says the people have a right to go and defend the Constitution. Article 88 says that one of the mandates of IEBC is to hold elections and referendum. And therefore, there is already in existence the fact that because IEBC exists, and their job is to hold referendum. The only question that is, what is it that we are going to hold this referendum on? And the referendum in this case would be on the removal. So that the moment you have accepted that it would be for removal, you go back like to the situation in 2004, even when the law was not this developed, where the High Court basically said that a new constitution would need to receive the approval of the people. And that was to be through a referendum. Therefore, there is nothing more, because the Kenya Constitution expressly recognizes a referendum and it provides that it will be held by IEBC. And the rules of the referendum is simple majority, that the people who come out to vote, if the majority are in favor, then the motion is carried. Therefore, I do not think that you need any referendum whatsoever. The only thing that would have been required in a situation, we've been talking about the need to have a referendum law. It has taken forever because there are just a few referendum provisions in the Elections Act, which we are viewed to be inadequate. But it doesn't follow that if a law that ought to be put in place is not in existence, that a constitutional right would not be exercised. Constitutional rights can be exercised because in 2004, without a referendum act or the provision of referendum in the law, the High Court established the idea of a referendum, and it was held in 2005, giving birth to ODM. And in 2010, we also had the final referendum that gave us the 2010 Constitution. So it would be a false argument for anyone to argue that there is no procedure. There is an intact procedure already in existence. And the mandate to carry the referendum is on the IEC and the Constitution.
Thank you, Wakili.